14th, 2009 of the City of Santa Barbara Ordinance Committee. We are looking at today amendments to Municipal Code Title 17 regarding waterfront policies. Mr. Cronman.
Good afternoon, Mr. Chair and members of the Ordinance Committee. My name is Mick Cronman. I'm Harbor Operations Manager for the City of Santa Barbara's Waterfront Department. And as you're probably well aware, the city's waterfront department staff works on an ongoing basis with the city attorney's office to do what we like to refer to as code maintenance on Title 17 of the Santa Barbara Municipal Code. Basically, it's an effort to make sure that we maintain on an annual basis, when we appear before you anyway, the legal framework to administer the affairs of the waterfront in terms of our policies and regulations and even sometimes our programs. And so today we're here before you with three substantive changes to the municipal code that we are proposing that are captured in the attached ordinance. One deals with vessel partnerships, one deals with vessel impounds and storage, and one deals with legal and or illegal anchoring. I'll walk you through each of those briefly, and I'll try to let you know on which page of the draft ordinance the new language reflecting the changes can be found. Relative to vessel partnerships, the department has long required that slip permits be in the name of an individual. For a whole range of reasons, the department hasn't allowed nonprofits, corporations, partnerships, trusts, and what have you to be the persons named as the slip permittee. We have allowed, however, entities to own the vessels that are assigned to the slips. But in recent years, there has been a proliferation of the kinds of organizations, if you will, and associations that own vessels or in ownership capacity. Partnerships, LLCs, corporations, nonprofits are but a few. We actually see a broad range of those. And so a couple of years ago, we came to your committee and ultimately to City Council and requested the authority to ask these complex entities to be able to prove to the city that the individual named on the slip permit, who could be a partner in a partnership or a limited or have a position in a limited liability corporation or a trust, that they have the capacity to legally bind that entity relative to affairs concerning that slip. It helps provide peace of mind relative to indemnity for the city. It helps tie out administratively the relationship between the entity and the individual on the slip. So administratively, we understand that Joe Blow or Joe Smith, if you will, is actually can function in a legally binding capacity for the corporation that owns the boat. And it also gives us a heads up relative to making sure that any kinds of changes relative to the slip permittee are done in legal compliance with our rules and regulations, especially relative to something that might trigger a slip transfer fee requirement, which is a $250 a foot fee that the city applies for adding partners to a vessel permit. So those are the reasons we did that. That was approved a couple of years ago. Since then, it's been brought to our attention that the regulation we had allowing individuals who owned vessels and had slip permits or entities to not notify the waterfront department if there was a change in equity interest in that vessel, whether it be by gifting or by sale or whatever, as long as it didn't trigger a slip transfer fee, that they didn't have to notify us. The ordinance, the draft ordinance language you have before you today is a follow-up to what I just described was done a couple of years ago, when in fact would reverse that and then require that entities inform the waterfront department within a prescribed amount of time if there is a transfer of interest, if there is a change in equity interest, and that the waterfront department be informed of that so that they're able to determine A, that there's a binding capacity, B, that that there's not a slip permit transfer required, et cetera. And so basically that would help us, again, on the administrative front, and it would help us make sure that we are getting the revenues that we are rightfully owed if, in fact, a slip transfer is required. Most of the times it's just administrative, but there can be times where we have to delve into it deeper to see if there is a fee owed the city for what functionally would be a slip permit transfer. I will, in all candor, admit to you it's not simple. It's often complex because the corporate structures are complex, the partnerships are complex, the nonprofits themselves are even complex, but they're typically for good causes, and so they're very much, easy to deal with relative to seeing a new person on a slip permit or seeing a change in terms of vessel ownership. So that language you'll find on pages 1 and 2 of the draft ordinance, and it helps. It's really a follow-up to what we did a couple of years ago relative to entities owning vessels other than not individuals owning vessels. The second draft ordinance change you have before you involves the impound and relocation of vessels. As you're probably aware, the Title 17 allows the waterfront director to impound and relocate vessels that have been abandoned in the harbor or illegally moored or docked or berthed in the harbor. Most of the time, those impounds are the function of a non-payment, though they can at times be the function of an enforcement action. But what happens is, if we're forced to impound vessels in the harbor, especially larger vessels, it takes up valuable space, especially during summertime, and again, we're not able to recoup some of the revenue that we could be getting through visitor fees while we're waiting for, let's say, a lien sale process to take place or any other complexities relative to that impound to unfold. But especially relative to vessels that we take out of the water and impound in the harbor district, what happens is it ends up clogging up our maintenance yard, it ends up clogging up our ancillary facilities where we need to do our work, where we need to have operational elbow room, if you'll allow me. So the draft language you see, and it's captured on page 8 of the draft ordinance, would extend the authority of the waterfront director to impound and store said vessels in a place of his or her choosing until any legal or financial issues related to that impound and storage are concluded, at which point the vessel would be returned to its rightful owner. And the third and final substantive issue we have before you today involves anchoring vessels within the waters of the harbor district. In 2006, we came before you and before City Council with for lack of a better expression, a marine zoning plan where we developed a summer anchorage, we call a seasonal anchorage, a year-round anchorage, which is further to the east, and in between developed the permitted mooring area that I think most of us are familiar with now and remains in operation. And as part of that undertaking, as part of the associated resolutions and ordinance changes and what have you that accompanied that attended that effort, we council adopted language prohibiting anchoring from sundown to sunrise in areas within city waters in any other spot other than the designated summertime anchorage, the seasonal anchorage, or in the year-round anchorage further to the east of the mooring area. But by oversight, and it's caught up with us, we neglected to include the narrow 300-foot strip between the eastern end of Stearns Wharf and the very western beginning boundary of the seasonal anchorage. So factually, I would like to say in theory, but it's proved out to be factually, if somebody wants to go anchor in the middle of the day in the area between the summer anchorage and Stearns Wharf, which of course poses a danger both to the wharf and to Mission Creek and other resources of the city, that was not prohibited in language, current municipal code language, until now, hopefully, when we look to sort of close that loophole. And our interest is not just making it nobody can anchor there other than nighttime hours. We want no anchoring there because that was the intent of the entire zoning system that we established in 2006. And the language reflecting this you'll find on page 11 of the draft ordinance. It would really just close that loophole and reflect what was intended in the first place. So in conclusion, we believe the adoption of these amendments will help clarify the code, Title 17, in ways that will help us tighten up the legal framework and make better our ability to administer the affairs of the waterfront and in our ongoing effort to do code maintenance and stay on top of what's necessary in Title 17. And with that, I'd be happy to answer any questions. I would note that Harbor Commission approved these notions for your consideration and advancement to Council at its May meeting. Thank you.
Just as a reminder to members of the public, if any member of the public wishes to speak, they must fill out a speaker's slip in the back. And questions, beginning with Councilmember House.
Great, thank you very much. Mick, thanks for the great presentation. Question on the second of the proposals here, and it's maybe not related specifically to these changes, but in general how we handle impounds. We have people who live aboard their boats, and we have others that have working boats in the harbor. For those who live aboard their boat, they have a number of personal effects and things that may be very important to them on board. Of course, the same thing is true for those who have a working boat. There's tools and maybe computers or things that they need, whether their boat's impounded or not. What provisions do we make for, if a boat isn't being impounded, for the folks to be able to access some of the critical things that may still be on board when the boat's being held where they can't get access to it?
Thank you for the question, Mr. Chair and Councilmember House. We permit them access for the very purpose of doing what you just described, for removing personal effects, items of importance, medicine, whatever might be important to their well-being and survival, quite frankly. We provide that access. It may be a monitored access because this is an impounded vessel. Not monitored like we go in and stand there in the cabin and watch, but we may have an officer stand by allowing the access to the vessel and then closing up the vessel once the access is completed.
So they'll know where the vessel is, and they have access to it under the conditions you were just talking about.
That's correct, and I should also add, and it's in the staff report, that the draft language change in the ordinance also provides for an impound hearing, the right to an impound hearing, but for any person who has had a vessel impounded. This is a notion that's reflected in other bodies of law, particularly state law, and we believe it's important to reflect it and include it here.
Okay, and then one thing in the staff report it did mention was that under the current situation, there's been some difficulty with people making unauthorized access to their impounded vessels. And could you describe that and how this is going to help?
Sure. Mr. Chair, Councilmember House, that's correct. Although we don't like to think of ordinance changes as being targeted, particular situations or individuals. We like to think more broadly. There are times in which issues are brought to mind that need change that are precipitated by those activities. And you're not incorrect. We recently had a vessel that was impounded, and an individual actually climbed the fence of our maintenance yard to access the vessel that had been impounded. This is just simply not acceptable for a number of reasons. And so the language you see, having the ability to relocate a vessel to a facility of our choosing, or the waterfront director's choosing, would help mitigate that as well and prevent those illegal entries.
Okay, and the facility you're talking about would be a mooring location possibly, or perhaps another storage yard somewhere?
It could be either, but quite frankly, a mooring location is more subject to wind, wave, theft, all kinds of interventions that could complicate matters relative to the city's liability. It would be more likely to a storage yard and a secure facility of our choosing on land.
Okay, great. Well, thank you for answering my questions. The rest of this seems very clear to me, and I'll be interested to hear any public comment. Thank you, sir.
Mr. Francisco.
Thank you, Mr. Chairman. Mr. Cronman, just a couple of questions on the first item. How many would you say of these corporate entities are there?
Mr. Chair, Councilmember Francisco, if you'll allow me, I'll speak to a guesstimate number, and I'll also speak to the trend, if I may. I think in the harbor proper, I want to say 10 to 15% in that ballpark, and I'm sure my colleagues will, who may be listening, may correct me on that when I return to the office. but I think the percentage of the new boats and slip transfers especially that we see now, the percentage is higher. 30% would probably be a rough guess. I haven't run those numbers exactly, but it's significant enough that we've been paying close attention to this for the last couple of years. It's much higher than it used to be 5-6 years ago when it was more the now it's really more on the norm side of things when it was more less frequent in the past.
Okay. And then just a sort of a operational question. Presumably some of these entities have, I don't know, possibly many partners who may not live in Santa Barbara. How will you communicate this new ordinance to the people who are a part of that entity, or are you only planning on communicating it to the person who's designated as the slip holder?
We would typically work through the slip holder, but the slip holder is certainly entitled to provide us with any contact information they wish, and we encourage them to do that for reasons ranging to this, an administrative issue, to reverse 911. So we always encourage them to do that, and I appreciate the reminder, especially with corporate entities. If they wish further contacts, we'll redouble our efforts to make sure they let us know if there's anybody else they need contacted relative to issues with the boat listing, bilge pump not working, overdue slip fees, whatever the issue might be.
Right. Okay. Very good. Thank you.
Sure.
I also had a couple questions about that subject area. Are you not afraid that this will create a decrease in slip transfers and therefore a long-term decrease in that element of the waterfront budget, and therefore a long-term increase in that which is demanded from regular slip holders to make up for the lack of slip transfer fees?
Mr. Chair, I'm going to try and answer your question based on what I think you're asking. We've had a long-term concern about people not paying slip transfer fees, not so much because they were deterred from the notion by administrative protocols or legal protocols, but because $250 a foot at current rates times a 40-foot boat is a lot of money. And anytime there's a lot of money involved, there is the tendency to not want to pay it. And so our efforts have typically been, and this is included as sort of a subset of the notion you're seeing here, is to make sure we have as acute an administrative understanding of the relationship between vessel ownership and the slip permittee as possible, so that we have an understanding of what should or would or could trigger a slip transfer and hence a slip transfer fee, and what shouldn't. I don't personally believe that this language would hinder anybody who wants to do a slip transfer in the normal and proper and appropriate way. I think what it does do is it puts on notice corporations, partnerships, et cetera, that even though they may have complex internal relationships, when then they enter a 30-day to 30-day license agreement with the city for a slip permit, we have certain requirements for administering that slip that they need to be aware of, because it could be a function of the fact they're trying to split the baby in terms of the cost of the slip and paying the slip fees and what have you. And that's all well and good. We have no intention of getting into their affairs. We're only concerned in an administrative sense of making sure we can tie out the permittee to the vessel ownership. Long-winded answer. I don't think, the short version being, I don't think it would affect individuals' willingness to pay slip transfer fees when they're owed and due appropriately.
I guess my question is a little bit different, is if we allow anybody to set up a corporation and have that own the slip instead of an individual, half the harbor could do that and then never have to pay a slip transfer fee when they transfer that to someone else. They just sell the limited liability corporation. So could that not potentially be a way for everybody to avoid ever having to pay a slip transfer fee?
That could be, theoretically, Mr. Chair. It's been that way for years and years, and your concern is not without weight and without accuracy. But I think the reality is that very few people like to take the chance and put at risk either themselves or the liability of their entities to do an end run around that. We have as many mechanisms in place to try and ascertain. They're going to have to change whoever signs that permit, if the new permittee, and that would be a transfer, by the way, would require a transfer fee. If I'm representing the corporation and unless the ownership of the vessel changes and a new person is put on the slip as a function of the corporation changing and they can legally bind, they might have a case. But any time a person changes and they do a merry-go-round, let's say, and Joe is the slip permittee one day and Sally's the slip permittee the next day, they have to prove to us that they can legally bind the corporation with their signatures. And most up-and-up LLCs and partnerships and trusts usually don't play those kinds of games because of the liability potential.
Yes, Mr. Wiley.
I may have misunderstood, but I think there's some miscommunication here. The city only allows individuals to hold slip permits. A corporation cannot be a slip permit holder. So there would be no ability to accomplish a backdoor, if you will, transfer as a slip permit by holding it in the corporation and then selling the corporate assets. It's the only thing that we don't insist that individuals own the boats. Boats can be owned by individuals, by partnerships, by corporations, by LLCs, by trusts. And this ordinance amendment is only requiring that when there is a change in ownership, whether it's a corporation or a partnership or whatever, that the city be advised of the change in the ownership with respect to the boat. But again, the permits themselves have to be held by the individual. And that has you might buy a controlling interest in a corporation that owns an expensive boat, but you'd be making a mistake if you didn't get the individual held that slip to transfer the slip into your name because you bought a boat and you're potentially going to lose your slip. So that's, right, I think, how we control it.
Okay. Got it. Grant?
Yes, just Mr. Wiley, thank you for that, because I seem to remember that conversation where we really worked over this whole end of it, that it was the person, not the corporation or even the partnership. There would be one person that would be the accountable person to the slip. So just to verify, there's this notification of the ownership interest change that we're doing here. When, let's say there's 5 buddies that own a boat together and one of them sells out to someone else, and so what we're doing is requiring that new partner be registered as a part owner. That's the first piece of the puzzle, right?
That's correct. We're requiring that they notify the waterfront department of that.
When that happens, do we charge a fee for that notification?
Not for the notification, no.
So that what happens is we're just informed now of who's actually in the group that's owning that boat.
That's correct.
Okay. Then what would trigger a transfer fee would be if the named partner in that group speaking for the whole were to change. Then that would be the trigger for a transfer fee.
Correct. If the person on the slip permit, as Mr. Wiley described, changes, that would trigger the slip transfer fee.
Mm-hmm. And that is also true, I think, if I understood. Let's see. If one of the partners were to pass away that was noted, was the key person, and somebody else were to take over, what would happen in that case? I think it's actually in here, and I'm trying to, notification of death and all, but that one, can that avoid the fee if they transfer it over to someone else in their family? I think that's what it was, or something. Looking here to see. No, it's not something that's agendized for today, but there's a issue here about what happens not later than 30 days after the date established of the death certificate of the slip permittee. The administrator or executive of the state shall notify the waterfront department, and that's the little window of time. Okay, termination, and they would have to remove it from the harbor or pay a transfer fee upon its transfer of interest. to someone else.
That's correct, except in the case of a surviving spouse.
That's right. That's
or a legally registered domestic partner.
There you go. Okay, thank you. Okay, thank you very much.
We have Mr. Pennington wanting to give public comment.
Good afternoon. I'm here for Title 17. I've done a lot of research on Title 17 in the last year or so, actually a couple of years. It's come to my attention that Title 17 itself is in violation of federal and state law. I believe that the Waterfront Department has a little bit too much authority invested in them to regulate, designate, and enforce ordinances that are in violation of federal and state law. I am one of the vessels that was impounded, as everybody knows. And there's been a lot of illegalities regarding that impound itself. I've looked at archives. I've went over like tons of documents regarding Title 17 and how it was enacted and who enacted it and the Coastal Commission and all that. And it was Mr. Wiley had specifically told the commissioners that vessels would not be taken out of the water. And that seems what happened to me. And the vessel not only was taken out of the water, was actually dismantled. I tried to get a reason why, and there doesn't seem to be any, but possibly they wanted to move the vessel somewhere else. It's in violation of the tow law. There are laws regarding towing. There are laws regarding who's authorized to do tows and how tows are done legally. And there's several violations there, meaning that you must give the owner prior notice, and I think the law says like 10 to 15 days prior to impounding. And it goes on and on and on and on. I've talked to the Coast Guard Commandant, Alameda, and he literally told me that the Santa Barbara waters are to be designated, regulated, and enforced by the Coast Guard and Department of Transportation. Their authority may not be redelegated. So there's a question of authority here and rights to do certain things. I think before the city, enacts ordinances regarding people's welfare. I live aboard my vessel. I do own a business in this town, and as a result of being impounded and my boat being taken out of the water and demasted and all that, it's caused a big tort to myself. I believe that that this ordinance itself, which I'm in the process with the courts to look into the details of this ordinance, and I believe that this ordinance needs to be taken off the books. And that's my opinion. And I actually,
Pennington, you've articulated your opposition to the entire Title 17. Do you have any comments on these specific changes to Title 17?
Yeah, well, anchoring and mooring vessels within that 300-foot boundary that the waterfront was talking about, and getting like permission to drop anchor in the city. I've not seen to this day what a permission slip looks like. It says you must have permission from the waterfront director to be in city waters and drop an anchor, but there's no such permission slip. Or how does that work? Or how does a cruiser coming down from Vancouver know that if he drops his anchor, in city waters, that he's in violation of a city ordinance? He doesn't know that. It's not written in the CFRs. It's not written on any federal map. On a federal map, it doesn't even show federal regulated anchorage, for the reason there is no federal regulated anchorage. So cities cannot enact anchorages if the federal and state government are not enacting them, because it would be their jurisdiction to do so. So I think it's an ordinance that's causing a lot of grief to a lot of mariners out there, including myself, but mostly tourists coming into this town. We're putting a lot of limitations on them on what they can and cannot do. We're forcing them to tell the waterfront director what their purpose is here in town, how long they're staying, and that's a violation of like privacy at that point. I mean, the cruiser is not obligated to tell the waterfront, what their business is in our town. I mean, and by the way, have to ask permission to be here. I mean, if I come in with a vehicle in our town, I don't have to come to the city and tell you what I'm doing here, and where I'm at. I mean, that would be kind of ludicrous. But if you're coming on a sailboat, you must do that. So there's a lot of violations here of civil liberties and civil rights, and I think that I'll be discussing this with you on a regular basis, and I'll get to the bottom of this. Thanks for the share.
Thank you, Mr. Pennington. Does staff have any response on information briefly?
Mr. Chair, sure, I'd be happy to respond to some of Mr. Pennington's comments short of the broader comment about Title 17. First of all, it is on the charts, on the NOAA charts. The anchorage area and mooring area are marked on NOAA charts. Second of all, the permission to moor, and Mr. Wiley can correct me if I go astray here, but my understanding that the permission to moor is an implied permission. It's not, we don't hand out permission slips. You can imagine what an administrative burden that would be. There's an implied permission to anchor or moor in the legally permitted areas. And what we use that ordinance language for is to inform and educate, and that's 99% of the cases, people who may come down from Vancouver and don't know where to anchor, and they happen to anchor in the middle of the mooring field or 200 feet from Stearns Wharf. We make polite, friendly, educational contacts with them. I think our Harbor Patrol, quite frankly, and I'm biased in this regard, does a tremendous job of customer-friendly service to folks who may just misunderstand the rules. The only time that we make more stern enforcement contacts relative to this issue is when people absolutely refuse to either recognize the validity of the statute or refuse to recognize the jurisdictional aspects of the waterfront's oversight of the area, or flat out just refuse to obey the law. Finally, speaking to relative to the impound, the current language that is in the ordinance before you, not the draft language, but the current language, speaks to the waterfront's ability to impound a vessel anywhere in the harbor district if it needs impounding, and not just in the water. And speaking to Mr. Pennington's claim that it doesn't have the jurisdiction or the right to do that, the harbor district itself, of course, is defined as, and I'm reading straight from the municipal code, the entire waterfront of the city, including all navigable waters and all tidelands and submerged lands, whether filled or infilled, situated below the line of mean high tide bounded by the limits of the city, as now fixed or hereafter may be extended. And that, without question, includes our harbor maintenance yard, where vessels are typically impounded when they're put on land.
Do we have any motions or comments on the changes from the committee members? Mr. Francisco.
Thank you, Mr. Chairman. I'd be happy to move the recommendation.
Is there a second?
I'll second that, but I have just a comment, if I may. I think that I got Mr. Croman, the key answers here, that the Title 17 as a whole, not just the parts that we're talking about today, that we in the city have the authority to have this kind of and enforce this kind of an ordinance in our municipal code, and that the issues that go all the way down to some that were mentioned having to do with providing information about how long somebody's going to be here, what they're going to do here, is that part of our, I mean, is that a normal part of our procedures, or is it, I mean, how does that work and how does that fit into this? Because I didn't see that in here. Might be here.
Sure. Mr. Chair and Councilmember House, the only time that the city has an interest in how long an individual is going to stay in the harbor district are the following cases. Number one, of course, in a slip, where we have rules and regulations relative to payment schedules and days in the slip, and quite frankly a 28-day limit, and then they have to leave the slip for 5 days. Those are well articulated in Title 17. We have no requirement for them to stay a minimum time or a maximum limit in the anchorages unless they exceed a 30-day limit, which, of course, unmanned and nobody on the boat technically equals an abandoned vessel and could trigger another process relative to addressing an abandoned vessel. But no, we don't tell people how long they can stay in the boat and how long they can't in the seasonal or winter anchorages, and neither in the mooring area as well. In the mooring area, people are able to come and go as they like and stay as long as they like in the permitted mooring area.
Okay, thank you. Well, my second is based on that these changes here don't get close to the larger issue of 17, and I do support these changes that we have in front of us.
We have a motion and second to recommend changes to Title 17. All those in favor, please say aye.
Aye.
Aye. Opposed? Motion is unanimous. With that, we'll adjourn to, I guess, next week.